Good afternoon, everybody. This is Omar Serrano with the Tilted Lawyer podcast. I am joined by the world famous Leanne Newton. She is an entertainment legal commenter. She does have a YouTube channel. She's also really big on Instagram. She's big on TikTok. She has an X, all of the things that I'm not really big on. And so here we are. And it's been a long time coming. You were on the show on Friday when I had Anita on, and you guys were, it was mostly just me explaining why Baldoni got his suit dismissed and trying to get everybody to understand why that happened and why it's not such a big deal. But it came off like it was it felt like a funeral. Like Anita was beside herself. Like I felt like you had more understanding with it a little bit. At least you understood the mechanisms.
Yeah.
But just look, I think that with this case, with the dismissals, it did everybody a lot of good to take a step back from this lawsuit. And I think part of the trouble with this case is you really have to simplify it. Like that's what we do, right? Even in math and law, it's the same thing. You got this big equation. The first thing you do is you try to simplify. Now, way back in December, when the case broke, we didn't know anything about the case. It was around mid to late January, really when they dropped Exhibit A, that people really started looking at Blake Lively's allegations sideways. Like these were ridiculous. It's preposterous. And you had people like yourself and a host of others, like Anita is the whole, I'm pretty sure you could hear that siren that just drove by. But people started to look into the merits of her claims based on what was publicly available. Obviously, you're not going to see the things that are not publicly available. But I went so far as to say that this sexual harassment complaint is so ridiculous. When this case is over, when this trial is done, it will not have been about sexual harassment because that's preposterous. It's going to be about how public relations is run going forward. I went so far as to say that this is going to be a case that they're going to talk about in entertainment law circles in law schools about how to conduct PR, how it defines defamation, how a smear campaign works, what you can say, what you can't say, how you could potentially conspire with media outlets or whatnot. But we didn't really contemplate much the merits of the sexual harassment complaints because they were just kind of like, nah, really? All of that, huh? And then we got caught up in trying to figure out what it was that Blake Lively did. And I think that in the countersuit, and with the help of people, the likes of Anita, of yourself, and others, we sort of exposed that it makes all the sense in the world, meaning it would make all the sense in the world to a jury, that Blake Lively had designs on It Ends With Us as a movie franchise, that she had every financial motive and career motive to try to wrestle control from Justin Baldoni and attach to her name as a producer, owner of the franchise, whatever. I think that the Baldoni parties are going to argue that Blake Lively valuated this movie as a $1 billion franchise that was going to span or have a lifespan of maybe 10 to 12 years with sequels and things like that, whatever she planned on doing. And the mechanism for wrestling control away from Justin was at first she was just going to try to kick him out, But then she catches wind that maybe they've been protecting themselves and maybe she's been acting in a way that subjects themselves to potential legal liability going forward, and perhaps there's this fraudulent scheme. And so they started having internal communications that Brian Friedman is aware and he's preparing things or whatever. So they catch wind that the Wayfarer parties are preparing this litigation, and as a prophylactic measure, I remember saying that word and introducing it like way back in January, and I was like, oh, I've never heard that word so much. But as a prophylactic measure, Blake Lively decided that, you know what? I'm just going to claim sexual harassment. We've been laying the groundwork for this since December. And with her 17-point letter and all the ridiculousness and the shenanigans that were going on henceforth, she files her CRD complaint in December of 2024. After the VanZan lawsuit, after she caught wind of potential future litigation, she did this as a way to potentially chill and maybe insulate her from various claims that were already brewing with Justin Baldoni. Now, look, we get caught up in all of that. And it turns into like this conspiracy theory about what actually was happening going behind the scenes. But from a legal standpoint, we can't prove any of those things. We could theorize and whatever. And like Justin Baldoni, he tried to do his countersuit based on defamation, based on fraud, but he was never able to plead a defamatory statement that was authored by Blake Lively, because the only defamatory statements he ever identified were privileged under the CRD complaint. And I think that we had gone over that on Friday and understood that that was the basis for the 12B6 dismissal. And then Judge Lyman turns around and says, similarly, you can't claim defamation against Ryan Reynolds because his wife had these claims, and it's reasonable to conclude that he believed his wife, even though, you know, it doesn't really pass the smell test to so many others, lawyers even, that suggest that calling somebody a sexual predator to potential future employers is perhaps a bridge too far. Never mind. It's gone. It's been dismissed with prejudice. Whether or not he has legal recompense in the form of an appeal is anybody's guess. But now that we're not distracted with having to jump through all these hurdles and these hoops, these gymnastics of having to tie in, well, Blake Lively was the co-conspirator, the mastermind, and she used Ryan Reynolds as an agent of hers and her PR team to spread these defamatory lies, thereby maliciously defaming Justin Baldoni. That was the defamation. That was the fraudulent scheme, and having to go through all of those shenanigans. We don't have to worry about any of that. Now we're just literally focused on the ridiculousness of her claims. And that, although it doesn't appear to be the position of strength that it might actually be, might be the hugest blessing for Justin Baldoni going forward in this case, if all he wants to do is clear his name. And so I don't know how you feel about all of what I just said. I'm not even sure if it makes all that much sense. But
it makes complete sense. I actually completely agree as well. I think in a way, and I do, and I understand why people feel the way they do about Judge Lyman, and you know, it didn't feel fair, and some of the dismissal still doesn't feel quite fair. I said on Friday, I think they could have given them wiggle room to replead that, because that was too far, and there were some other problematic decisions. But I think if you look at the bigger picture, there's a couple of things that are going to benefit, particularly Justin Baldoni, actually, from that decision, especially from Lively's defamation claim, the claim against Lively being dismissed, is he is not currently and should not be on the hook for the treble damages and everything, because he did not decide anything on Section 47.1. So therefore, he's got, Judge Lyman really has no grounds, even if Lively does come and, you know, file her motion for the damages and everything as he's invited her to do. I don't think if he's not just made a decision to dismiss based on it, I don't think he should be awarded anything based on Section 47.1.
So I'll lead you down some of my legal thinking, because I've been all over the place with this. One of the things that I was afraid of with the 12B6 dismissal was issue preclusion. In America, the federal legal system, if a judge decides an issue, and when you dismiss something with merits, it's basically decided, you can't bring up that issue. And so I was worried by him stating that Blake Lively did not bring this complaint with malice, if it was now, meaning Baldoni, if he was now precluded from proving malice at trial, and I don't think so. That's an absurd result, because what could happen is he just defends the claims and then catches her in lies on the stand. You can't just say, oh, well, issue preclusion. Well, we didn't know that she was lying. That was proven at trial. So look, maybe for 12b6 purposes, but that's not litigation on the merits. We didn't even make it past the pleading stages. And so I believe there is no issue preclusion here. I believe that he can still insulate himself from treble damages. Now, I can't say that for certain because they haven't brought a 47-1 motions treble damages motion in front of Judge Lyman for him to rule on it. But if they did, I'd imagine that he would refrain from making that ruling until the end of trial. That makes all the sense in the world, because what's required for her to be protected under 47.1 is that it was brought in good faith. And we don't have any need, because he's still actively defending himself. She hasn't prevailed yet. And he has the opportunity to defend himself. They haven't made any decisions about whether or not she brought this in good faith. And if she's found to be a liar on the stand, then she's potentially not entitled to 47.1. I think that would be argued in whatever motion is, I'm sure, coming.
Isn't and this is where I'm a bit hazy on the American law, but isn't section 47.1 like anti-SLAPP? Aren't they procedural laws? So therefore, federal courts should not actually be awarding fees.
We actually talked about this on Friday. It is not procedural.
Right.
And I'll tell you why. Because normally with an anti-SLAPP lawsuit, that includes, for it to work, a special motion to strike that is filed by whoever would be the protected party. That conflicts directly with federal procedural law, and that's why it's not honored in a lot of different states, specifically in the Second Circuit. But 47.1, it's similar to an anti-SLAPP, but it's not exactly an anti-SLAPP. And it's substantive because it affords protections that don't conflict with any procedure. Like, for example, 12b6 was the federal rule that was used to dismiss Baldoni's complaint. That had nothing to do with 47.1. It had no role whatsoever in judges' legal analysis of whether or not to dismiss. Matter of fact, he says if you want damages, you're going to have to bring a motion under that statute. I'll decide it later, but had no bearing whatsoever on 12b6, on the dismissal. Therefore, it's not procedural. It's substantive. Now,
I thought that was the case. I've seen like some mixed opinions with some of the attorneys that are on TikTok.
I know. I know what you're talking about. Yeah, I think Cassidy, when I talked to her, she was talking about this one lady named something Golden.
Oh, not actually Golden.
Yeah, not actually Golden. Yeah, I think she made a clip making the claim that you said, that 47.1 is procedural. It's not substantive. I just disagree with her. I don't know if, hey, she might be right and I'm wrong. Everything that I know about the law tells me that it's not substantive. But you have to understand the reason why the reason why anti-SLAPP is procedural is because it has a procedural component to it. Does that make sense?
Yeah, it does.
There's literally they have the California rules of civil procedure. They have the federal rules of civil procedure, and the rule is if it conflicts, it's procedural. Federal's going to win. That's the rule, right? That's what she said in her video.
Yeah.
The reason why it's not procedural is because there's not a procedural mechanism attached to it in order for it to apply that makes it substantive. And so I'm not trying to attack or say that I disagree with her. She may very well be right. This is one lawyer's opinion. And honestly, I hope that I'm wrong, because that would kind of take 47.1 out of the purview, wouldn't it?
Well, I'm inclined to think that you might actually be right on this. And again, I love Not Actually Gold and most of the other little girl attorney and all the other lawyers on TikTok. They're amazing. But I feel like, well, if it was precluded on the grounds of being procedural, then why would the judge have invited her to bring the motion to apply for it in the first place?
Yeah, and I think it's Judge Lyman's language that he uses was he made a point to say, look, I'm not involving any discussion of 47.1 and its applicability in my decision for this motion. If you want fees under 47.1, you're going to have to bring a separate motion. That should be the number one tip-off, that it's not procedural, it's substantive. And it's substantive as in California has awarded that protection to people who make sexual harassment claims. And since both sides have already agreed in their pleadings that California law should apply, that's the only reason we're talking about 47.1 in this case. You could have made an argument that it shouldn't apply because California law shouldn't apply because of New York or because federal or whatever. I don't know, whatever argument you wanted to apply, but both sides said it should apply. So I don't know if anybody contemplated 47.1 on Baldoni's team when they made that decision to just acquiesce to that, but they did. So here we are. But my point is, it doesn't matter. It doesn't matter. It is what is done, right? So at worst, and here's the thing, her defense against defamation is already over. So whatever fee she's incurred from December to, I guess, June 9th, where she used it to defend against defamation, it's capped. Multiply it by 3. I estimated somewhere between $4 to $6 million, somewhere between 12 to 18 million would be the total amount, right? If he prevails and shows her to be a liar, then he's going to be entitled to attorney fees and costs himself. And I promise you, his attorney fees are probably going to be in excess of $18 million.
Yes. Yeah.
So let the thing proceed to trial. And now the strategy going forward is going allegation by allegation, and just the same exercise that we did back in January, looking at each allegation, each claim on its merits. And when you do that, and you're not so distracted by the fraud stuff and the defamation stuff, because you're trying to prove your own claims, I think that you have a much different outlook. So in the caption, I forgot, I put in the title of the thumbnail, said that something like Blake Lively is in for hell, or I forgot what I said, but it said something like that. They're about to unleash the wrath of hell on Blake Lively. I mean it, because now we're not distracted by this stupid shit. And it makes all the more that I've sat and thought with this, it makes all the more sense to dismiss the entire complaint. Because what we're going to do, they're going to plead like breach of contract stuff. That was the weakest part of their complaint. Like way back in January, I was talking about, we don't even know what the contract was. Nobody signed any contracts. They were just kind of going off and doing their own things. They kept on changing the rules over and over and over again. And I had made a mention that, look, they keep on acquiescing to her demands. And every time they give in to her demands, they're telling her how great she is. Good luck proving a breach of contract in court under that context. And so I think Ask Two Lawyers had made the point. So we're going to go to trial, and over and over and over again, they're going to talk about how Justin Baldoni was calling her a creative genius and how she's so invaluable. And the Wayfarer, Jamie Heath, and all these other people are talking about how great she is and invaluable she was to the project. Forget all of that. Let's just focus on what a liar she is. And the only way to do that is dismiss the entire thing. Since it's not defamation or fraud, we don't want it. Just get rid of it. Let's just talk about how she's an effing liar and focus on that. And then they will have the option, if they choose, like if it goes so poorly for Blake Lively at trial, like they catch her lying on the stand, they catch her with dozens of inconsistent statements, or, whatever they do, but the jury decides that she is a liar. They can bring forward a subsequent malicious prosecution lawsuit against her. They'll have the option to do that. Yeah, it's going to necessarily subject them to another trial. I don't know if they're going to be up for all of that. Everything I've heard about Baldoni is that he just wants to clear his name, so he's probably not up for that, but they'll have the option to do it. And so all I'm saying is Blake Lively is not out of the water. And so it's just now we're focusing on our strengths. We're not so distracted by, look, if you got LeBron James and Luka Doncic on the same team and you're worried about how to get involved like all of these other like role players and wondering why they can't score, well, sometimes just give your best players the ball and let them score. I apologize for the sports analogy, but focus on your strengths. And that's all we're doing. And if you just go back and you lean in to the complaints, I mean, I got my notes from way back when. Way back when. She talks about the kissing scenes, right?
Yeah.
They're gonna use lively. I mean, she says basically that Justin took liberties in initiating unscripted kissing actions that were supposed to be scripted in the filming of the kissing scenes, right? They're
Yeah.
going to take Lively's video memorialized behavior and they're going to use it against her. They got her on tape. I don't think that she was expecting that, but they got her they have her own behavior. They got her own prior statements. They have her on video initiating intimate contact in some of those scenes. They have Lively pulling Baldoni in to kill. Hey, how long was I talking before I realized that I was by myself? Hey, Leanne, are you still there?
Yeah, I'm still here.
How long was I gone for? I just went on a whole rant.
I think you were gone for about 5 minutes.
Are you serious?
Yeah,
Oh my goodness
you
gracious.
just disappeared. I didn't know what
What
to
was
do.
the
I put in the live chat. I was like, what do I do? I was about to start answering questions, like just to fill time.
I was getting on this impassioned. Oh, that's so
Lauren
disappointing.
said every time you go on an impassioned rant, you just like you either mute yourself or
I
you
don't
just
look at my screen. I just start talking. That's what happens. And then I asked, you know what happened? I asked you a question. My question was, Leanne, is there any answer that Lively could give under that circumstance that would be an acceptable answer? And then it's like, oh, we lost Leanne. It's like, oh, wait a minute.
No, Leanne was still here.
What was the last thing you heard me say?
I can't remember. It's been that long.
Oh my gosh. Chat, what was the last thing that you guys heard me say? It was 8 minutes? No way. No
Yeah,
way.
it was a while. I mean,
That
you were
whole
kind of
oh
you were
no.
talking about you know, that how they've now freed up basically to kind of passionately and you know, concentrate on the defense now and pull
Did you hear
apart
my
her.
rant? Okay, did you hear my rant about how there was a moment in time where her behavior shifted?
I think that's where you kind of froze at that point. I did hear that, and I think then, yes, at that point we lost you.
Okay. My point was, so they're gonna ask her at trial or at deposition, Blake, for months leading up to this specific text message. And maybe I think it was the no teeth one where he started talking about his wife and kids, right? But there
Yeah,
was a definite moment where we all kind of wondered whether or not she was feeling rejected or not, right?
yeah.
My point in even bringing that up in my line of questioning was that, look, so you guys are friends. You're talking about your families. You're taking pictures with your kids. You're exchanging health secrets. You're exchanging all of these pleasantries. And you guys are like the best of friends, right? And he's such a great actor, and you're such a great actor, and everything is all rosy over there. But there was a distinct moment of time. What was it that Justin did? What
I
was
think
it that he did?
I think he denied her the dailies was when I noticed a huge shift.
Explain, talk more about that when he
So
denied her the dailies.
she wanted access to the dailies, didn't she? The daily the footage, the raw
Mhm.
footage, and he kept pushing back, and she kind of got huffy about it, and she kind of kept pushing, and then she wanted to know if there was someone else. You know, like, oh, is it just you that has, you know, control of this? Is there no one else who could say yes, you can have it? Um, she didn't seem to like it, and she pushed and pushed and pushed, and got away in the end.
So
Um,
my so this is my point then. So you, in your mind, that's the moment when there was this shift, right? It was when she was denied something.
well, there was
My
a
question to
small. I
her
think there was a sorry. The other thing there was actually another time which may have bit preceded that, and I think that's when she didn't get the feedback she wanted for the rooftop scene. Like where he said, you know, he complimented her and said, "Well, I'll use some of yours and I'll use some of mine. We'll make, you know, do a bit of a mix." And because he wasn't showering her with praise, that's when the dragons texts come in, and you know,
Mhm.
and all of that, and you know, well, don't forget, I have these very famous, powerful people around me, and that seemed to be. I took that threat that as a threat. That message, I did see that as a, well, they can help you and they'll work wonders for you know, and
Yeah.
they protect me.
No, I agree with you, but my whole point, look, there's like two maybe distinct moments, but they all center around something that Blake Lively was denied, right?
Yeah,
My point in that is I will ask her point blank, what did Justin do specifically that changed the tenor of your communications with him?
mm.
At what point in time were you guys not friends? What did he do? What did he say? Was it the onesie thing? Was it the trailer park thing? The trailer park, or when you invited him into your trailer? Was it
Or
the Jamie Heath thing? Was it the
when
kissing thing?
when he
Yeah.
criticised her wardrobe choices, he had to relay that message as well from Sony that, you know, what the public had seen, the comments on the wardrobe choices hadn't gone down well.
So the point is that it's all gonna tie into some event that's not gonna make sense to
Yeah.
the jury, right? Did you hear me go on my rant about when he was pulling him in to kiss her during the kissing scenes?
No.
So they have her on tape, they have her on video when she made these allegations. Little did she know that, holy shit, the tape was running. And so her own behavior, her own prior statements, where she talks about like him taking liberties with the kissing scene. Turns out, wait a minute, show me where it's in the script where you pulled Justin in to kiss her. Where was that in the script? Show me.
Yeah. Because she admits to doing that as well in her first amended complaint. There's a footnote where she says, well, just because I improvised kissing doesn't mean it was okay for him.
Okay, is that an acceptable response to you as a prospective juror?
I agree that two wrongs don't make a right, but then I sort of question, well, hold on, if improvising kissing scenes is not a normal part of acting, and it's something that you don't like, then why are you doing it to someone else?
The point is, if the allegation against Justin is initiating unchoreographed kissing in a scene, and she's doing the same thing, it seems to me that there's a culture there, or that's like a common thing that happens because, hey, I don't know if you've ever tried to like pull off like a choreographed anything. It's really hard to get it right.
Yeah.
Like gosh, I mean, I don't know, like choreographed dance. I'm not like a choreographed dancer. Or choreographing a speech. How many times have you tried to pull off a speech that you've been practicing and you wanted it to come out a very specific way, and in the moment it just doesn't come out that way because Jesus, and it's hard to do. It's hard to pull off choreography. Like choreography is literally how you exactly want it to go, but how you exactly want it to go is rarely how it ever happens. And so that's going to come off to be ridiculous. What was the severe and pervasive behavior that Justin was engaging in?
I'm still trying to find it.
Yeah. They're going to highlight that Lively continued to work amicably with Justin all the way through filming, collaborating with him closely, talking about scenes, talking about all kinds of things. During that period, what was the severe and pervasive harassment that she experienced? Now, look, she's already outlined it. She's going to say, "Oh, it was the kissing scene. It was him coming into my trailer. It was the Jamie Heath, whatever. It was the fat shaming and all of that." Is there any answer that you could envision that would be forthcoming if I ask her, could you just tell me what was so severe or pervasive that prevented you from working with Justin Baldoni or Wayfarer Studios in general? Could you envision a response from her that would make sense to a jury, that would actually lay out or demonstrate severe or pervasive behavior?
No, I don't. I can't see it.
I feel like if Friedman wanted to, he could 12B6 the sexual harassment allegations.
Do you know, I said this. I actually did my video. I did it with Anita actually last week with Anita and CJ, and I actually said, look, I'm not surprised that the motions to dismiss in Wayfarer's complaints were granted, because if you look at their complaint, that is not how they wrote the complaint was not a normal way of writing a complaint. It had very little kind of lore in it, and it was all filled with, screenshots of text messages and emails and all that stuff to get all the evidence in. And I appreciate that, like, it's not a normal lawsuit, because if I was or you were working for your average Joe who doesn't need PR, it's not a big thing to them, then we would not be writing hundreds of pages of a lawsuit which had, a big PR emphasis on it. And I can see why there's an issue with why I can see why Judge Lyman was sort of struggling to find the legal arguments there.
Hey,
However,
Leanne, I got to check. Mahone just sent me $2 to tell me that chat has no audio of either of you. Could you guys hear us? Is that a yes? Is
yeah.
Okay. Well, I don't know what that was about, P. I don't know what that was about. I'm assuming that, was that when I was gone for 8 minutes going on my rant? It was such a good speech, man. I was Atticus Finch. I was Matthew McConaughey. You missed it.
But I did also say, though, that likewise, Blake Lively's own complaints are over exactly the same. They were just, padded out with all of these screenshots and, all this background scenario and inflated concerns and everything, but very little legal argument in there at all.
Here's my theory. The best way that they could prove that Blake Lively is a liar is to simply attack her at trial on these ridiculous claims. Why would you want to get rid of her weakest argument?
No, exactly.
I mean, I could 12B6 it, or I could depose her on it, or I could cross-examine her on it. Why would I leave so much meat on the bone? We just got to about how, part of the benefit of not having to defend of dismissing the entire thing is we get to focus on her weakest aspect of the litigation. And all of our strength is going towards exposing her weakest cause of action. Why would we just 12v6 that? Makes perfect sense, doesn't it?
It makes complete sense, because I also think, I did say, and I firmly believe that I think if they had filed, if Wayfair had filed a 12b6 themselves, they probably would have had it granted too, because Lively's claims were just as useless, to be honest, from a legal perspective. But I agree with you. It's better to keep her in. It's better to test her claims thoroughly and and go through step by step, methodically pulling them apart with evidence. And then that kind of closes the door then to it as well, because if 12b6, then it can, she can still go around and do her press tour and, continue to make the allegations. And if people listen to her, which a lot of people do, especially kind of the news outlets and the PR agencies and the talent agencies, they got a lot of they got connections in a lot of businesses, a lot of Hollywood connections. So unfortunately, people do listen to them. So I think the best thing he can do is to clear his name.
Well, check this out. I mean, there's so much, I'm not going to get through in a 1-hour podcast. All of the ways that they're going to attack her, but one of them, by the way, I know that you practice law over there.
Yeah.
Do you have extensive trial experience, would you say?
No, not extensive trial experience. I represent in some tribunal situations.
Do you have
I'm more trial? Corporate law.
Okay.
So we don't have to. It's more sitting and writing.
I've done that.
Contracts and things, and working with international companies. So that's why I feel confident to read the international law. I don't feel like it's an issue with stepping into a different jurisdiction. But
right.
I thought the section I practiced in, I didn't really need much trial.
I can tell you this, that situations where you get to cross-examine an opposing party on as weak of a complaint as Blake Lively has filed against Justin Baldoni is a dream scenario. There's so much meat on the bone. I wouldn't even know where to begin. It's like if you're a trial attorney, it's like you really got to contain yourself, because this can't be a self-serving thing. This has to, you really got to map it out. You got to choreograph how you're going to attack her. But there's just so much there. When I do most of my cross-examinations, most of the time I'm focusing on like maybe 1 or 2 or 3 at most, like key aspects of the cross. With her, there's so much. There is so much. So if there was such severe and pervasive sexual harassment on the set of Wayfair, Blake, why does there not exist a formal HR complaint
Yeah.
in a process that was made available to you? Why does there not exist a complaint of the harassment that you experienced? And then she's going to say, well, I tried to give an HR complaint. Yeah, but you tried to give it to Sony. Yeah. And then they told you to file it with Wayfair. True. So why didn't you?
Yeah. And why didn't you contact SAG-AFTRA?
Is there any acceptable answer for her, from her, that you could think of that would cure this point?
No, there isn't. And I know she leans heavily on the 17-point thing as well. Well, they signed it. Look, I actually can't find really anything that stands up to the legal definition of sexual harassment in there.
No.
It's like, well, she wants to take over the nudity rider of another actor. She wants this producer. She wants that, producer. She wants this composer. And it's like, well, so, but what's missing from that 17-point list of demands, I call it, is
actual sexual harassment.
Yeah, it's actual sexual harassment. This person, and specifically, this person is not allowed to do this. This person is not allowed to be left alone with me during, any time. This person, it doesn't say who's done what and what the issues are at all. It just says, I want to choose my body double. I want to choose my stunt double. I want to choose my producer. And it's like, well, what's that got to do with protections?
Well, I'll tell you how Friedman's going to spin it. He's going to spin it like this. He's going to say that, look, you didn't file an HR complaint.
Yeah.
They gave you a mechanism to complain about sexual harassment. You never took them up on the offer. But then you have this 17-point letter, and Wayfair Studios, in their infinite wisdom, because we are a company that values the feelings and perceptions of its employees, regardless of whether or not we think it's ridiculous or not, they accommodate a meeting, and they have everybody there, you and your husband, whoever makes you comfortable, and we listen to your 17-point letter. That was not an admission that there was some kind of nefarious thing going on with the behavior on set. It was, look, if this is what makes you comfortable, we will accommodate you. Tell us what we need to do to make you feel more comfortable. And it wasn't a formal complaint, but we honored it anyway. And we honored what you asked us to do. And you continued on this path of basically disregarding your commitments to the studio to advance your own financial agenda. And in that way, that's how it's going to go and close an argument, right?
I think so, yeah, completely. Because, it sounds like, well, she's asked for all these things and she's got it. I don't understand, though, is they're trying to spin that as this is a contract. So this is a contract that's been formed. Now, obviously, I'm struggling to see, because obviously her coming back to work is what is being deemed as the consideration part of the contract. But she's already contracted to do that anyway. She's been paid for that. So her work doing, finishing the project was already part of a different contract. I'm not sure how it's supposed to be considered a binding contract.
Well, check this out, Leanne. This is the beauty of dismissing Baldoni's complaint. You don't have to worry about it.
No.
You just don't. I mean, because the argument would have been, we don't have a signed contract. And so where are you going to build the four corners of the contract?
Yeah.
Well, you don't have to, but if you were to try to construct that would be a tribal issue, and it would be based on the conduct of the parties. And they would have to look at how everybody behaved. Because look, obviously people had an understanding that they were bound by something, regardless of whether or not it came in the form of an enforceable contract, is beside the point. We have the ability to enforce an imaginary contract based on the behavior of the parties. That's where they would have to go. But we have Baldoni doesn't have to waste any time on that issue. If that's something that Blake wants to bring up and she wants to argue that somehow there was a breach of contract, that's her deal, man. We're just going to focus on the ridiculousness of her claims and how she's a liar.
But the other side of, I think, that may help Wayfair as well with their claims being dismissed is, I think initially they weren't going to look at what they could do to have the these text messages that were obtained through the VanZan thing. I think they originally weren't going to consider having them kind of prevented from being being presented at trial, because they were using them themselves, and they were kind of bring them in their own version to say, look, here's the full text log. But now I think that now that all of their claims have been dismissed, so they don't need the text messages in their own complaint, I think that might be an avenue they might pursue next.
Let's talk about the VanZan, because look, I know there's discovery disputes and stuff, and I know that that's not really a discovery dispute that has anything to do with Lively versus Baldoni, or does it? Because look, Lively and Reynolds are objecting to that as non-parties to the Stephanie Jones versus Abel lawsuit and all, and I don't know what they received by virtue of the VanZan lawsuit. I don't know that.
No.
How does it apply to Lively versus Baldoni? The only real way that it could possibly apply is in determining which evidence is admissible or not in Blake Lively's lawsuit. The reason why you haven't seen Blake Lively do victory laps and dances and speeches about how, I am a champion for women's rights and I'm standing up for all the sexual harassment victims in America and in the world and all of this, is because she and her lawyers know that the storm is coming. And it would be fool's gold to try to celebrate the dismissal of the Baldoni lawsuit, because the greater implication of that is, well, shit, now we got to defend. Now we have to prosecute our claims. And there might be some real nefarious stuff that comes from the VanZan discovery. And we've talked a little bit about fruit of the poisonous tree, the way that works. I'm not sure how it works where you're at, but the way that it works in America is in a criminal law context.
Yeah.
If law enforcement violates your constitutional rights in a way that produces evidence, whatever evidence that was produced and whatever came from that evidence, meaning it led you to other things, it's all inadmissible.
Same here.
Yeah.
If the police don't have a warrant for something, they can't admit it as evidence.
Right. And so there's not really a rule like that in civil court, but I and a number of other attorneys believe that it should probably work the same way. And so the only real reason that we're interested in the VanZan thing at all, I mean, look, it may have criminal implications for Lively, for Reynolds, for Stephanie Jones, for that matter, whoever was responsible for it. There may be criminal implications for it, but how it affects the Baldoni case is, if it's determined that they already illegally obtained evidence and they were using the Doe VanZan lawsuit to launder the evidence, meaning give it some kind of legal standing in this litigation, it may be deemed to be inadmissible, effectively gutting whatever evidence Lively was going to rely upon to prosecute her allegations. Does that make sense?
Yeah, and that was my thinking, because then that would be basically the vast majority of their retaliation claim gone.
Yeah, I'm really doing my best to try to pay more attention to the comments in chat. Here's one. Omar, what was the strategy of Ryan naming himself CEO of VanZan so late in the game? I feel like he believes it was to summon. It doesn't effing matter. It doesn't matter. They had to produce something. Now, they asked specifically, it was brilliant what they asked. Honestly, they just wanted to know, Show me the articles of incorporation of this VanZan business entity. Who's the CEO? Who are the partners? Who are the shareholders? What is the business purpose? It's like all the stuff that you have to file with the states to deem yourself a legitimate business. Show me all that stuff. And so I honestly didn't see what years Ryan named himself the CEO. It doesn't matter if he named himself CEO in 2012 or more recently. It almost doesn't matter who the CEO is.
It was just the other day. It was. I mean, would that kick in anything like spousal privilege? It shouldn't, because at the time of the VanZan lawsuit, he wasn't the CEO, and it was just. And Blake Lively herself in her.
Wait a minute. Does it say that he was the CEO as of like recently?
Yeah, like literally the other day.
No kidding.
Yeah. Before then, it was that shell. It was that kind of incorporation service I told you about that does fictitious things. But Blake Lively said in her first amended complaint that she received documents pursuant to the subpoena. So, and then more recently as well, in that kind of letter that her law firm wrote regarding the motion to compel the VanZan subpoena, she also gave a copy of the subpoena and the documents that were obtained as in response to the subpoena. So, I think she can't really get out of the fact that she had some control, because otherwise, why is she receiving the documents?
Is there any record, do we know, of who the CEO was at the time of the lawsuit?
No, it was an assumed name. This is a certificate of assumed name.
Okay.
So there will be a paper trail, because you have to file a certificate of assumed name if you're going to use a fictitious name for a business entity.
Well, the point of them asking them those questions was they're just trying to what they're trying to do. They're trying to demonstrate that this was a bullshit lawsuit, right? At the heart, that's what they're trying to do. Yeah. And so they could say that Reynolds was the CEO. They could say that Lively was the CEO. Whether or not it matters who was the CEO, I'm not exactly sure. Because marital privilege is going to apply no matter what.
Yeah.
But the whole crux of what they're trying to prove in even asking that question was this a legitimate lawsuit? So VanZan, as I understand, was like formed in what, 2013 or something like that?
Yeah, I think so.
It was formed in 2013, and it was mostly used for payroll purposes, is the way that I understood it. Like they paid certain bills as a result.
No, I think it was used once to buy furniture.
That's what it was, to buy furniture. In other words, it was not really a legitimate business. It was like probably mostly for tax purposes.
Yeah, probably.
And they file this Doe lawsuit. Can you do that? Yes. But was it frivolous? Well, what business did VanZan actually engage in? Who was the contract with?
Yeah.
My issue with the subpoena was always that I'm not the subpoena with the lawsuit was that you claim a breach of contract. What was the contract? Who were the contracting parties? And so I don't think it really matters who's the CEO now. What matters is, was it a legitimate lawsuit? And if you focus just solely on that, if the only thing that VanZan existed in 12 years was to buy furniture one time, and you file a lawsuit in New York, which gives you subpoena power.
Yeah.
And you use that to actually issue a subpoena in a lawsuit unrelated to the current lawsuit, but contains evidence that is now contained in the instant lawsuit. Is it frivolous or not? Yes, it is. And what should be done about it? Oh, so many things. There's potential criminal implications to that. I've talked about that once. There's like 8 or 9 different criminal counts that are at play if somebody wanted to prosecute them on that. But more importantly, what were they ultimately trying to do? And we all think that what they were trying to do was launder evidence, legitimize evidence that was obtained illegally. What's the effect of that in this civil lawsuit? It should be similar to criminal courts, that whatever they obtained by virtue of the subpoena is deemed inadmissible, and whatever evidence was garnered by virtue of the obtained evidence from the subpoena should also be inadmissible. Maybe. Now they're just going to have to litigate that. I'm not even sure how that's going to work. But ultimately, that's the reason why they're poking around at all.
Could Friedman bring abuse of process?
Yeah, he can, but he's not going to do that without having a firm basis for understanding what's going on. I mean, he already has a firm idea of what he thinks they did.
Yeah.
But he is not going to bring such a motion without having all of his ducks in a row.
No, you've got to have all the evidence. I think I said it to someone earlier, like, we can all sit back and look from the sidelines and say, well, it's glaringly obvious what happened here. But when you dealing with judges and juries, it's not that simple. You have got to have the evidence, and you've got to know what you're alleging has happened.
Especially when you've already been 12B6'd. You don't want to just like all willy-nilly just throw out any random motion out there. He's got no deadline to do it. If he's building a case, and when the time is right, he's going to bring something. It's not going to be nothing. Something is going to happen as a result of VanZan.
Yeah, I think that's the number one question I get as well. Is, well, when is Friedman going to say something in the lively? No, VanZan's only just come into the Jones case. Yeah. When is it going to come into the lively case? And what I keep saying is, well, you can't just whip it in, and drop it. It's got to come in at the right time in the appropriate manner, and that has not happened yet, but we are getting there.
No, we're getting there. You got to be patient. Look, trial's in March of next year.
Yeah,
that gives us a good 6. Gosh, is it already July? It's already July. We got to get 8 months before trial. So he could bring it now. What? He's got no deadline. Really, other than the trial. I believe it's like it would have to come. Well, I'm pretty sure it could come at any time before final judgment on the case. And so, if you got no deadline, then just wait until you get all the discovery and then go.
Could you see a scenario where they bring some kind of claims against VanZan as a company?
No, because what are you going to recover from VanZan? Because ultimately, if you believe that it's a sham corporation, then you're going after the people that own the sham, right? You're going after Reynolds and Lively, if that's what you're going to do. And ultimately, I'm not even sure, because what they used that to initiate a Doe lawsuit that was frivolous. And so, what would be the remedy? Probably sanctions, probably the inadmissibility of certain evidence. I'm not sure what cause of action they would tie that into. Fraud is already out. Remember, we're not trying to prove fraud anymore. We don't have to think about these things. We're only focused, like we said at the top of the show. We're not focused on. We're not distracted with these questions anymore. All we got to worry about is defending ourselves. The only reason why we're interested in VanZan is to attack her lawsuit, and to the extent that we could do that, that's all we're concerned with. Now, in the context of like a malicious prosecution, maybe you could use it in that, but you'd have to sign Justin Baldoni up for a second trial after he finishes this first one. And that's a lot to ask of anybody, honestly.
There are multiple members of the Wayfarer party, so even if he's not, there may be scope that one of the others could potentially, because they'll all have the right to pursue their own kind of.
Yeah.
I think Jennifer Abel has been harmed the most, really, by the text messages in particular.
Right, and Jones v. Abel, that is a separate lawsuit. That is a separate lawsuit that stands on its own, separate from Lively v. Baldoni.
Yeah.
But nobody asked me about Jones v. Abel. They always ask me about Lively v. Baldoni. So could it be used for fraud? In that case, sure, it could.
Yeah.
And for Justin Baldoni's purposes, what does he care? I mean, he probably cares because he's a good dude. But it's like,
Well, they've got their own case as well, because they're also suing and being sued by Stephanie Jones.
right. There's all kinds of separate litigation that is going on with this case, and so it's not limited to Lively v. Baldoni. It's easy to forget that fact sometimes, but no, Jones v. Abel is its own thing. The only reason we're really talking about it is because of, obviously because they're the PR people in this instant case, but also because it affects Lively v. Baldoni. That's why we talk about it, because it may have implications for that.
Yeah.
And so, Leanne, we've been going for about an hour. Have you said all the things that you wanted to say?
Pretty much, yeah. I mean, I'm inclined to agree with you. I think more focused now and more streamlined. I think Baldoni's got a really good chance of defeating her claims in court, because what her allegations have also got to meet the legal definitions of sexual harassment.
Yeah.
And then we've also got to prove that she made her complaints in good faith. And I just don't see any evidence. In fact, and we're getting more and more evidence. We've had the guy who was literally in the birth scene with her come out and say, she wasn't nearly nude, and all the set was closed, and by the way, I am actually an actor. I'm not just his friend. And
a Shakespearean trained actor, wasn't he?
Yeah, more qualified than her. So I'm quite confident, between all the footage and everything and all the cast and crew. I do wonder as well if they're going to look deeper into, whether anyone else was kind of extorted, bought off in a way, similar to Taylor Swift, allegedly. So, and if that's why the main cast and the author all turned against him, then I think that could be a talking point as well. But we will see. I think she's going to have a difficult battle ahead of her to win now.
Yes.
Personally.
My whole point in making this stream, I'm going to stream later on with Lauren as well. We're going to probably talk about some other stuff.
Oh, I'm streaming with Lauren tomorrow.
Yeah, she wanted me to talk about, I think there's content creator subpoenas she wanted to get to and some of this VanZan. We're going to talk about more about this later tonight around 8 p.m. Pacific Standard Time. But my whole point in doing this stream was we need to stop treating this case like Baldoni's lost. He hasn't lost anything. Now, he's still very much going forward in this thing. So, do not mistake this dismissal as like this monumental loss. Lively has some questions to answer, and they will be answered in due time. I
do have one question, if that's all right, just really quickly.
Sure.
I wanted to kind of from because obviously you're an attorney in California. The subpoena on Friedman's firm for things like the business accounts and his mobile phone records. I mean, we don't really have subpoenas particularly over here, but that just seems wild. I wanted to know what you actually thought of that.
I'm not familiar with the subpoena on Friedman. Was it on Friedman's firm?
On his firm, she has subpoenaed the phone records for every member of staff that works in the firm and all the business accounts, amongst other things. But I mean, those ones in particular, I mean, obviously there's going to be a attorney-client privilege, work product.
So she could ask for whatever she wants, and I'm sure that subpoena got objected to. When did they file that?
There's a motion to quash in California.
Yeah. Because you're right, attorney-client privilege, privilege stuff, work product, all those things. What is the relevance? I imagine they filed a motion to quash. And
I just don't see the reason why she needs the business accounts of a law firm or the mobile phone records of, an attorney who's in active litigation against the opposing party.
If I were willing to venture a guess, I would guess that she's looking for communications between Abel or Jones or whatever PR firm and Friedman's office that might have contributed to the orchestration of a smear campaign. That's how I imagine they would do it.
I had a different take. I thought, because in Friedman's affidavit that was ended up being struck off the docket, he put the dates of the phone calls he had about Taylor Swift. I think he started with, I had a phone call on the 14th of February. I called them back. And then I had a series of other phone calls with the person. And my hypothesis on it is, because she's made such a stink about the Taylor Swift stuff, I think she's looking to see if she recognizes a number.
Maybe. I don't necessarily even disagree with that. That makes a lot of sense. It does. I don't know what they're going to rule on the motion to quash. I don't understand how they think they're going to get those kinds of records. I've honestly never had my firm ever subpoenaed for any reason.
No.
Certainly not for business records. Certainly not for like a communications or whatnot, because those are understood to be privileged, I guess, for whatever reason. But yeah, I'd imagine that would be a quashed subpoena. I don't know. I think that your theory makes more sense than mine does.
I mean, she's also desperately trying to get the subpoena transferred to Lyman as well. So I can't see that happening either, though. I think it's going to stay in California, and I agree. I can't see a world in which she gets all of that.
No, there's no chance. There's no chance. Yeah, I got to look at the subpoena to see what specifically was asked for, but that looks like a really quashable one.
Yeah.
And so I guess we'll see. But Leanne, I had a lot of fun with you. We're gonna have to do this again real soon.
Yes, I'd love to.
Yeah, whenever you want to come on the show to talk about anything, you just let me know and I'll make it happen.
Oh, lovely. I will. You'll hear from me a lot then, probably, because it's nice. It's the first time I've kind of had, like a sort of a direct one-to-one almost with, with a fellow lawyer. So it's been nice from that perspective too.
Yeah, I agree. I haven't honestly. Well, I talked to Ask Two Lawyers, and I guess you
on them as well.
The only lawyers I've talked to about this case so far. So unless I'm forgetting somebody, I don't know. But yeah, it's been a real pleasure.
Thank you so much for having me.
And we'll definitely do it again. But folks, I got to go. I will be live in a few hours with Lauren to talk about some stuff. But until then, I love you all. Drive home safely if you're not home already, and if you are, then I don't know. It's for some people it's their bedtime, and so I wish you all the sweetest dreams. And I will catch you guys next time. Bye-bye.